It's my pleasure now to introduce our third panel of the day on international antitrust challenges. And rather than introduce the panel, I'll have the moderator, Mr. Thomas Barnett, handle that. But let me introduce the folks that are here on the panel. We have Jean-Francois Belly, founding partner of the law firm of Van Bael in Belly. Ashok Chawla, Chancellor of Tara University and former chairperson of the Competition Commission of India. Professor Andy Chen, professor at Chung Yung Christian University and former commissioner of the Taiwan Fair Trade Commission. And William Kovacic, director of the Competition Law Center at George Washington School of Law and former chairperson of the United States Federal Trade Commission. And of course, our panel moderator, Thomas Barnett, partner at Covington & Burling and former Assistant Attorney General of the Antitrust Division at the United States Department of Justice.
Thank you very much. I appreciate the opportunity to participate in this event, and particularly have a great honor and privilege to be moderating a panel with such distinguished backgrounds. I think we will generally jump into the topic since you've got the introductions here. We are going to at least try to talk about some of the challenges that arise for businesses who are faced with a patchwork of international competition regimes with sometimes different processes and standards. I think we're going to try and cover this in a fairly broad range. We're going to open with a few remarks from each of the panelists, and then we will move into some specific questions. And if we have time, we'll take questions from the floor, and I will, let Mark be the judge of that. So, with that, let me first turn it to Jean-Francois, who's obviously one of the most distinguished practitioners in the European competition law. So why don't you lead us off?
Well, thank you, Tom. So I will start with just a few remarks about recent developments in the EU. The first question, which I will briefly tackle, is whether we can expect a higher standard of judicial review in competition cases in the future. Because, well, as you know, especially in the last 15 years, the standard of judicial review by the General Court has been relatively low, with a few exceptions and also a few cases, except for cases related to minor issues such as the determination of fines in cartel cases. The General Court has tended to uphold almost systematically every Commission decision which was appealed before that court. For example, when you take abuses of dominance, the last time a Commission decision in that field was overruled on substantive grounds in the EU was in 1983. So before the General Court was created. Now, will this change? There has been an important development in the way the General Court is organized, in the sense that, reacting to the excessively long time it took the General Court to handle its cases, the Court of Justice proposed to increase the number of judges in the court, and for various political reasons I won't discuss, it ended up doubling the number of judges. So from 28 to 56, well, soon 54 after Brexit. And this spectacular increase in judicial capacity arrived exactly at the time when the number of appeals in competition cases dramatically dropped. More than 80 cases in 2015, less than 20 last year. And so this has created some pressure on the court to make appeals more appealing. At the beginning of the year, the president of the Court of Justice gave an interview in which he said that he was confident that the number of cases would rise because there would be now more robust judicial review in the revamped General Court. Cases would be heard by chambers of 5 judges. The lawyers would find appealing to the court again more attractive. And a few weeks ago, the president of the General Court himself openly encouraged lawyers to file more appeals in competition cases, something that some commission officials felt was not too consistent with interinstitutional committee. So we will see what will happen, and maybe in a few months the Court of Justice itself will have an opportunity to show that the standard of review has changed for the better when it will issue its judgment in the Intel case, a case to which I will come back in a few moments. Another important development that we have witnessed in the last few years is the revival of the concept of exploitative abuses. For a long time, the Commission was focusing on exclusionary abuses, but as illustrated, for example, by the current Gazprom case, the Commission is addressing pricing. That case is heading for a settlement, and apparently the Commission has succeeded in obtaining some concessions from Gazprom that would limit its ability to price its product as it sees fit. And of course, we have seen that development also in cases more directly related to IP, like Rambus, another settlement, not to mention the Microsoft pricing case, in which the Commission refused to decide what would be the right royalty for Microsoft to charge for its interoperability information, simply limited itself to responding to proposals made by Microsoft, saying that each time these were too high, then imposed a daily fine of €2 million on Microsoft until it hit the right number. And this gave rise to a fine of €899 million eventually. Now, Intel. Intel, that's a very important case because of, well, some of its substantive issues, also because of the issue of extraterritoriality which it raises. Now, this is a case where the Commission adopted the decision. Intel appealed to the General Court. Of course, the General Court rejected the appeal on all grounds. Then Intel appealed that judgment to the Court of Justice, and last October, the Advocate General to the court, Advocate General Wahl of Sweden, delivered a very interesting opinion in which he basically concluded that the General Court was wrong on almost every single point. So it will be interesting to see what the Court of Justice is going to do after that opinion. And there are two issues which are of specific interest. The first one is about the treatment of exclusivity or loyalty rebates, rebates conditional on exclusivity or quasi-exclusivity. The General Court, upholding the Commission decision, said that these rebates are per se abusive, per se illegal. The Advocate General disagreed and said, no, they may be pro-competitive, and so you must assess them against all relevant circumstances. And of course, if the court were to follow that approach, this would open the door to a more economic, sounder approach to rebates in EU competition law. And the other interesting issue raised by the case is extraterritorial jurisdiction. Because all the contracts concluded by Intel with its OEM customers, Intel, HP, etc., were worldwide contracts. But they all involved deliveries of chips in the EU, so that gave the Commission jurisdiction over those contracts. But there were two exceptions, Lenovo and Acer. probably the Commission did not realize during the administrative proceeding, because this point was not really discussed, that these two contracts involved only deliveries of chips to China. And so the question was, well, does the Commission have jurisdiction over that conduct? The General Court said, of course, yes. The General Court said, the purpose of these, the effect of these rebates is that Lenovo, to take Lenovo as an example, did not buy chips from AMD, Intel's competitor. So Lenovo did not produce laptops fitted with AMD chips. So Lenovo did not sell those laptops anywhere in the world. And since the EU is part of the world, it did not sell them in the EU. And that was enough for the General Court to give the Commission jurisdiction. Now, again, Advocate General Val disagreed, said no, this is really too remote and too indirect connection to give the Commission jurisdiction. And again, it will be interesting to see what the court is going to say about this. So when, well, we are impatiently awaiting this judgment. My guess is that we should know by the summer.
Great. Thank you, and I didn't even warn you, we have a very handy shot clock up here, and you came in well under, so thank you. Now we'll turn to Andy Chen, who's going to give us a perspective on fairness and due process issues in Taiwan, and who should have a PowerPoint presentation that's hopefully loaded up. Yep.
Thank you, Tom. Thanks for having me here. I think we have just listened to the very wonderful presentation by Professor Wright. He mentioned that Taiwan usually refers to the United States for any new issues, and that is true. Yeah, each time when we have these new disputes regarding competition law and policy, we usually look to the motherland of antitrust, the United States, for any possible answers. But that is not what I'm going to talk today. Today I'm going to share some of the difference between Taiwan, especially, and the United States. And there are two issues that I want to cover today. The first is about the procedure rules. We have all these procedural protection rule concerning procedural protection in our law. For example, we have this administrative procedure law, and also this Administrative Penalty Act and the Taiwan Fair Trade Act, and also the regulation concerning some procedural regulations, such as the SS evidence and the materials. So as the basic framework of this procedural protection are already there. So that's the basic rule. But the difference is that usually in the legal tradition of Taiwan, competition law, antitrust law has been classified as a public law or administrative law. And when the law was classified as administrative or public law, it usually refers to that state. With respect to this kind of cases, the state usually enjoy a certain type of privilege, because the whole purpose of the law is to pursue public interest. So the mentality underlying this law is to give the state some special privilege in investigating these cases. So under that kind of mentality, usually in the law, they will give the government some exception to investigate the cases. We already have a law, but the exception gives government some power to make some exceptions. So for example, I think I make some example here. Usually, the government, the investing party could apply for the access to the evidence or documents, but if that kind of access is against the public interest purpose that the government is trying to pursue, then the government usually have the rights to deny this access. And similar for the public hearing process, the party might apply for the public hearing, but if that is, the government think it's not necessary for the investigation of the cases, and then he also has a discretion to deny the access. Of course, this kind of discretion is reviewable by the administrative court, But usually, in practice, the court will respect the decision made by the TFTC. So that's basically the general framework for the procedural protection. It's tending toward more likely the inquisitorial system. So if you approach the Taiwan law from the perspective of the adversarial system, which is more, I think, a more accepted principle in the United States, you might think that the procedure is not transparent enough or given the government too much power. But that is the current situation right now under the law. So that's the procedural part of the difference between Taiwan and the United States. The second part is about the concept of fairness. I think Professor Wright also mentioned about the Section 5, the FTC Act of Section 5. And we also have the similar legislation in the TFTA, it's Article 25, which empower the TFTC to prosecute patently unfair conduct. And under this provision, this provision has been used to the IP cases before. For example, I mentioned in the slide that the TFTC has applied Section 5 to the issuance of pre-warning letter. It means the IP holder send a letter to the competitor's customers without substantiating IP infringement first. Because that kind of conduct might create the suspense effect in the mind of the customer. So the customer might terminate the relationship, the contractual relationship with the competitor. And according to the TFTC, that will be constitute an unfair conduct. And that is based on the Article 25 of this article. The second cases related to Article 5 is to use the Article 5 to establish the market power. Especially, there is a special theory regarding the superior bargaining position under Article 25. By superior bargaining position is that, according to my interpretation, is a verticalized evaluation of market power. Usually, when we conduct antitrust analysis of market power, it's more like the horizontal process. We compare the market share with the competitors. But under this superior bargaining theory, market power could be derived from the vertical contractual relationship between the, for example, IP licensor and the IP licensee. If there is some kind of unique situation between these contracting parties, for example, there's a serious information asymmetry problem between licensor and licensee, or there is some kind of economic reliance relationship which make the licensee hard to deviate from this contractual relationship, the TFTC might treat that as an indication of market power. So that's what I mean by superior bargaining position. And that is the verticalization of market power. And under this theory, economic reliance become very important. So if the TFTC think a certain specific contractual relationship will create an economic reliance, by economic reliance, for example, information asymmetry or the long-term relationship between the licensor and licensee, that will be treated as a market power, and it could be a violation of the Article 25, even though horizontally they did not possess sufficient market share to constitute market power, traditional definition of market power. So that's the idea about our superior bargaining position here. Under that kind of theory, I think it creates some kind of problem. They might confuse American company or American law firms, especially when they are dealing with the TFTC. Under this theory, I think the distinction between competition and competitor began to get blurred by this superior bargaining position. And also under this theory, fairness become a more important element for TFTC to consider IP cases. And that is probably the TFTC will be more, they will rely on this theory to intervene in the evaluation of royalty rates based on the theory of fairness. And also under this theory, in practice, for those companies who raise the issue or raise the justification of charging high royalty rate based on dynamic innovation, the TFTC usually will be more skeptical about that kind of theory, because usually dynamic innovation is in the future. So if you try to justify this kind of high royalty based on some uncertainty about the future engagement in some subsequent innovation, I think that it is more likely to create this fairness concept within the TFTC. So under the Article 25, it is more likely those issues which conventionally we won't discuss or intervene in conventional antitrust legislation, it will become more likely that we'll intervene in those situations. So that's the some of the problem I raised based on this concept of fairness. But of course, I know that no matter whether be it inquisitorial or the concept of unfairness, I think in the United States you probably also have this kind of idea. So what I'm presenting here is simply a matter of degree. In China, in Taiwan, or actually in Japan or Korea as well, I think this emphasis on inquisitorial nature and also on the fairness is more as evident than those in the United States. And I think I will stop my presentation here. I'm more than happy to take your question later. Thank you.
Great. Thank you. We now turn to another region of the world, Chairman Chawla from India.
Thank you. Thank you, Tom. If this conference were being held 10 or 15 or maybe 20 years ago, I can assure you we would not have had this panel discussion. This whole issue of international antitrust challenges, in a way, is an outcome or the flavor of the last 15, 20 years when, as distinct from your competition law, which is 125 years old, as distinct from your patent law, the US patent law, which is more than 200 years old, the competition laws in more than 100 countries, maybe 120 plus, have by and large gathered steam in the last decade or 2 decades. And hence, this whole issue of how do businesses handle different authorities, different laws, different processes. And in touching on that and drawing partly from the Indian perspective, I'll touch on 3 broad issues. The first, needless to say, the most important, is an issue of legal systems, processes, the way business is done under the competition law or in the authorities. And you heard from the panelists from Taiwan. In India, for instance, for those of you who may not be fully aware, the Indian Competition Act enforcement is not more than 8-9 years old. The essential thing about the law is that it's an economic law which with civil penalties, no criminal penalties. The enforcement under the statute is what is given to what is called the Competition Commission of India, which is supposed to be an expert body, not really a judicial body. It brings together members from different disciplines. It gets the investigation done from the Director General of Investigation, who is administratively subordinate to the Commission, but is otherwise all his work, substantive work, is at an arm's length, so that the investigation is not sort of prejudiced by what the Commission thinks. And the investigator submits his report to the Commission. The Commission then follows the due process, hears the parties, and has the authority to impose penalties. That's the way it works there. The decisions of the Commission are appealable to the Competition Appellate Tribunal. That's provided under the statute, so that's the statutory appeal, and then one more appeal to the Supreme Court of India. So the jurisdiction of the normal courts and the high courts, etc., is kept out of the system. This is in relation to India, and you look at various countries, they would have different systems, different processes, some following the normal judicial route, some following a different route, etc., etc. So in this landscape, I think what becomes very important, and there have been efforts in this regard, is to try and at least bring some semblance of harmonization to the extent possible in the perspectives and in the way issues and matters which arise out of antitrust matters are are dealt with. The initial attempt, as many of you would be aware, was made through the WTO when it was sought to be brought into the agenda of the deliberations there, but it was dropped off and got off the table, I think, in the year 2002 or 2003. Basically, at the behest of the developing countries who thought at that point in time that maybe this is going to be an intrusion into their domestic industrial and trade policies, etc., etc. So it's no longer active today on the agenda of the World Trade Organization. The International Competition Network, on the other hand, which is the body which represents all the competition authorities of the world, in a sense a kind of trade body. The ICN has been looking at this issue very actively, and members here would be aware, those who participate in those forums, that one of the working groups works actively in trying to harmonize some of these practices and thought processes and the manner in which not just behavior cases, but more importantly even merger control cases, and of course the intellectual property cases, the relationship with the competition, etc., are going to be dealt with. So the idea is to try and bring various jurisdictions, particularly the younger and the newer authorities, onto a common kind of platform, which is in line with what the rest of the world is doing. And I think that's very important, because even those countries, even those emerging markets, their entities and firms are going to be operating internationally. So it's business and money are not one-way streets anymore. So that's an important thing which is being attempted. And I can recall a parallel example after the 2008 financial crisis. There was general panic all around the world, and the G20 was used as the forum to politically handle the situation, and the then President of the United States, President Bush, had called an emergency meeting of the leaders, etc. There was a lot of panic, and the first reaction, as happens in emergencies, is that, look, we must have an international law. We must have some kind of enforceable law which applies to all countries, and which takes care of how movements of money and is handled, and how too big to fail is handled, and so on and so forth. Very soon, and also the crisis was slowly abating, very soon wisdom dawned that is not going to be easy, because these are all sovereign issues. There are national laws. So countries are not going to submerge their sovereignty to get to that. So let's have harmonized basic fundamental principles, which then the Financial Stability Board was tasked to do, and that process is continuing, as you are aware. So something similar, I think, is important as to address the issue of the international antitrust challenges, and this is one area where the US can play a role. And I am a bit sort of confused today to hear that there are things here itself are in a state of flux and so on, but I'm sure that is a dynamic process always, and those things will get settled. But the younger jurisdictions naturally, quite obviously, look to mature jurisdictions like the US, the EU, the OECD group to be able to guide them. The second issue, which is in a way linked to the first issue as a challenge for those kind of authorities, including India, are the issues of human capacity. And I'm very happy to say that the CCI, for instance, got a lot of help from, howsoever ambiguous it might have been in the words of Joshua, but we did get a lot of technical help from the FTC and the DOJ in terms of secondments, in terms of seminars, in terms of outreach, etc., which are all very important activities to build the capacity to be able to then apply the legal architecture and make sense of the investigation and follow the due process and carry it to its logical conclusion. So this is something which is a very important thing. For the authorities which are going to handle these issues in various countries, not just from US, but also from the European Commission, which has a very robust competition authority. And the third issue is it's more sort of domestic, but very relevant in the analysis of antitrust matters everywhere. And this is the issue of the availability and the reliability of economic data. That very often becomes quite a problem in some of the countries, because unless you have good, robust, reasonably up-to-date data, needless to say, the analysis and therefore the economic evidence which will be required to build or settle the matter one way or the other at times becomes a problem. So these efforts are going on in some of these countries, including India, but that's another area which poses some kind of a challenge. And I'll stop here. Thank you very much.
Thank you. I guess I'll say I wish I shared your optimism that the disagreements in the U.S. will be worked out in the near future, but I guess that's part of what we're here for, to work on that. And with that, last but certainly not least, is former Chairman Bill Kovacic, who will give us a U.S. but even a global perspective, I suspect. So, Bill?
Thank you, Tom, and my gratitude to the organizers of the program and for having me here today. As Tom said, I'd like to talk about the role of the United States in influencing these developments overseas. Ashok Chalwa just described to you the environment that is a striking feature of the modern world. That is, since the Berlin Wall fell in 1989, there have been created over 100 new competition authorities. That hasn't happened in any other area of economic regulation so quickly across the globe before. In that environment, you cannot force people to do what you prefer. You can, in some instances, if they aspire to being part of your political institution, you can impose terms. The United States at the moment doesn't have any accession country states in the queue, so we can't impose those kinds of terms on new members. In that environment, you only gain acceptance through persuasion. I'd suggest to you the capacity of the United States to persuade today is fading. If it traded on a stock market, it's falling in a number of fairly dramatic ways. Its larger stature in the world, the persuasiveness of its position in these fields is eroding in a dramatic way. I spend a lot of time in Europe, China, and in Latin America, and it's hard to point you to any favorable developments on those fronts in any of those places. Every time a top U.S. official expresses indifference to the European Union or a blasé attitude towards NATO, that's a step back. Those step on the most sensitive and delicate toes of the relationship across the Atlantic. In a recent extended trip to Latin America, each meeting is begun by a semi-humorous joke about the wall and what that means for U.S. attitudes, a ghastly symbol of the U.S. presence in the larger world. And in all of these jurisdictions, and in so many areas, what the U.S. does is closely followed. Our colleagues in Beijing and the competition agencies read the statements of the official U.S. agencies within a 24-hour cycle in great detail. And the same happens in many other jurisdictions. So in this environment, which is enormously challenging and I would say is degrading, how does the U.S. have influence in this larger world? I think it starts first and foremost with having a coherent message. And that requires a different attitude on the part of the U.S. authorities about how they do work. I say this with great humility because if I'd understood this earlier, I would have worked much more closely with Tom during the time that we overlapped at the department and the FTC and do some of the things that I'm going to be talking about now. So if I was so smart then, I would have been doing this. But having learned about what I think is important, I'm going to discuss what I think is a good path ahead. To begin with, to be persuasive, you have to have a coherent message. That is, what is your view about the world ahead? It means as a practical matter, you have to formulate a common view, a common plan about what you mean to do internationally. That means taking humble and mundane steps such as exchanging texts, before speeches are given. Having a discussion of comments that will provoke a broad public discussion about U.S. policy and U.S. intentions. It means having a well-developed common discussion about the appropriate boundaries for the treatment of dominant firm behavior. In formulating a view about Section 5 of the FTC Act, that has to be a Department of Justice and FTC conversation because they are part of what is intended to be a joined-up system, a systemic process through which the two are complements and not substitutes for each other. You can't imagine having a coherent program unless that conversation takes place. As policy is formed, I dare say that didn't happen. Moreover, for areas such as distribution practices, for the whole array of matters that are under the umbrella of competition law and policy, you have to have an intimate discussion between the department and the commission about what policy should be. For example, it would be refreshing on a Friday afternoon during the ABA spring meeting week when the officials of the leading agencies do appear on the podium, when the individual agencies are asked to give an introduction, to have the heads of the two U.S. agencies saying, we're going to spend 5 minutes talking about our program. This is our vision for the world ahead. These are our priorities. And you will not see an utterance of a U.S. official in the coming 12 months that does not turn back to these themes and reinforce them, so that there can be no ambiguity about what we mean to do and how do we go about it. That involves a different approach to the cooperative relationship, the generally friendly relationship between the two institutions, a deeper form of integration. Without that, I don't see how you even begin a program of coherent, clear messaging across the globe where you speak for what you mean to do and what you hope to accomplish. Among the focal points for that kind of discussion would be, for example, what is your conception of good process? What do you think to be the must-haves in the development of a system, not simply with respect to the substance of commands, but how you do work? And in doing that, I think you have to confront anomalies in your own system and to seek to cure them. If you're at the FTC, for example, there is the annoying habit when key legislators request briefings on pending law enforcement matters to give it to them. The chair of a committee that is responsible for oversight or subcommittee can ask the FTC for a briefing on a pending merger review or a pending non-merger review, and by a vote of the commission, they receive it. Now, they announce in the letter that they send, we of course won't reveal any non-public information, but if I told you there was a jurisdiction, unnamed, that had a habit when legislators request briefings on pending law enforcement matters and routinely gives them, would you associate that with good practice or not? That's the kind of anomaly that has to be wrung out of the U.S. system to create a platform of authority and persuasiveness to have credibility in the larger world. I also think, as Ashok Chalwa was just mentioning before, there's a tremendous area to have continued influence in the form of technical assistance, and I give the U.S. agencies good grades on this score. In silent and quiet ways around the world, U.S.-based advisors are working with agencies in circumstances difficult and even more difficult, promote the development of good process-related norms. In Ukraine, 2 full-time U.S. advisors are working with the Anti-Monopoly Committee of Ukraine, which is seeking to undertake a basic makeover, is doing so over the past 18 months in extraordinarily difficult circumstances, but in a country that I would suggest to you where success would have a dramatic impact on the development of competition law in states that are severely challenged and in fundamental ways represent important foundations for peace and prosperity in the world ahead. U.S. officials are playing an excellent role in providing that kind of know-how. And what is the information that's important? How you look at a file, how you evaluate evidence, how you overcome a tendency to fall in love with a specific theory of the case, how you demand rigorous standards for examining evidence. I have a lot of confidence that over time, if you develop good analytical technique, that cannot help but press you in the direction of better substantive outcomes. And I think a continued commitment to this kind of engagement is indispensable to taking countries that in many ways need it the most and to promote the development in a fairly quiet but effective way of good analytical norms. A final ingredient that I think is indispensable if the U.S. is to have influence in this process in helping shape the acceptance, the adoption of superior techniques and norms is the continued commitment to the international organizations that my colleagues have mentioned. What's the problem? Those are often associated with being elitist, insular. They are part of the larger global swamp of institutions that are indifferent to the needs of the have-nots, that are insulated in a cocoon of plush hotels, restaurants, and experiences around the world that are so often damned in modern discourse that has a populist tinge as not being fully representative of larger interests. I think it is important for the U.S. agencies to build the case for the constant engagement, because the organizations that we've just been talking about are the closest thing we have to standard-setting organizations in a global scheme. And to demonstrate their useful capacity for developing standards that are effective and useful for the broad community of competition agencies is extremely important. And I'd suggest to you from the U.S. perspective, the value of these institutions, be they the United Nations Conference on Trade and Development, the Competition Committee of the OECD, or the ICN, the value of these kinds of international organizations is not self-evident to a large number of political leaders who regard them with enormous distrust. So, the sustained commitment to these kinds of projects, the investment of real resources, and by the way, it never comes on the cheap. This requires good people devoted in a significant way over time, becomes an indispensable part of the U.S. and its influence in larger affairs.
Impressive, Bill. 2 seconds left. I'm going to use the moderator's prerogative and ask Bill one quick follow-up question. Whether you agree, my own sense is that there is a lot more ink that is spilled and words that are used talking about differences between the two U.S. agencies than is spent on the areas of agreement. And if you actually look at the fundamentals, the blocking and tackling of dealing with cases and issues and analysis, probably 90-95% agreement with some important but smaller areas of disagreement. Would you agree with that, or do you think I've got a skewed perception?
No, Tom, I think when you look at, start from the microscopic level and work up, when you look at the work that goes on in routine merger reviews, for example, the methods for case analysis and the substantive standards applied in that process, you have, quite fortunately, necessarily, an enormous amount of commonality that is valuable. And I think one thing the agencies can draw on, because this is an unmatched reservoir of experience. When you take the two of them, if you ask who's done the most of these things over time, and partly based on that experience is in the strongest position to offer observations about what works and what doesn't, that's still unmistakably the United States, backed up as those agencies are by an incomparable system of higher education, graduate programs in law and economics that provide a remarkable unmatched pipeline of skill, talent, and literature into the field. A greater effort to join up that body of expertise and make it available and accessible as the basis for asserting what ought to be the foundation for good policymaking would be a way to show the work that has been done in a more effective way.
Great. Thank you. I'm going to start asking some questions, but I will give the panelists, if anyone has any specific comments on what's been said so far, let me know, and you're welcome to jump in. Otherwise, I will start peppering you with questions. Andy, I'm going to direct this one to you, though others can weigh in. You spent some time in your opening remarks on this concept of a superior bargaining position. It's a concept I've heard in a number of jurisdictions. I will admit that I struggle with this one as I think about a business, a general counsel of a company or business manager who's trying to figure out, well, how do I know where the line is? How do I comply with this? And would note that in the United States, there have been times where, not to pick on one agency, Bill, but for example, the FTC has gone after certain behavior such as oligopolistic behavior and tried to outlaw it. And the U.S. courts have stepped in and said, no, that standard is too vague or difficult to comply with. we're not going to let you do that. So my question is twofold. How does a business person in Taiwan comply, know where the standards are? And two, are the courts in Taiwan likely to provide some guidance?
I'm struggling with this principle too. So the reason for me to mention the theory is that it does play an important role in case deciding process, but it doesn't mean I agree with this principle. Actually, I'm a strong opponent of this theory. But with respect to your first question, how do the business community comply with this rule? I think the TFTC is trying to do that by kind of compiling all those cases that has been decided and try to derive some of the factors that they will consider in real cases. And also they have promulgated some guidelines on the determination of whether a conduct constitutes unfair, especially under the superior bargaining position. For example, there are three basic principles for determining superior bargaining position. First, the TFTC will see whether it is possible, whether the possibility of the contracting counterpart to deviate from the current relationship, whether the deviation is sufficient, whether there exists an alternative supplier to induce the switch of the business relationship. The third element is whether it is expectable for the company to deviate from the current situation. Usually, the expectability requirement will involve the evaluation of the market share. So, personally, I think this theory could be absorbed into the SNP test. Actually, if there's really a superior bargaining position, it usually means the relevant market might be defined narrower. You don't need a specific theory to conduct this kind of investigation. So we can still rely on the conventional market definition approach to take into account those specific factors. So the second question is about the court. I think the court is generally receptive to this kind of theory, but there are cases that the court specifically mentioned that it is vague. It is unlikely for the business community to comply with this kind of theory, and they overrule the decision by the TFTC. But I must admit that I think more than 50% of the cases will be supported by the court at this moment. Okay, thank you.
Okay. Jean-Francois?
Well, this is a concept, in fact, which comes from German competition law, where you have the idea of preeminent market position, which is something which is less than a dominant position. Also, French competition law has used that concept, and well, the Commission also has toyed with it, but that was a long time ago. For example, I remember the BP case during the first Arab oil boycott in '74, where the Commission said that in a situation of shortage, each customer is dependent on its traditional supplier, because when there is a shortage, you can't turn to any alternative supplier. But the essence of that concept is dependence. Mm-hmm. So I think this is something which you cannot approach it in the traditional antitrust framework. It's a question: are you dependent on a given supplier, or as a producer, are you dependent on the big distribution chains? So it's something which is not new. I mean, it has been used in Europe.
Bill?
Yeah, Tom, I think a comparative perspective that the U.S. could bring to this conversation is how, in many ways, these kinds of concerns migrated away from competition law into other areas of law that do not have the same overhang of remedies that you see in the U.S. competition system. No trouble damages, weaker, more light-handed forms of intervention. But where did they go? They went into state law in many ways. They went into sector-specific laws which Congress passed to regulate relationships, for example, between petroleum refiners and their retailers, automobile manufacturers and their dealers. And in state laws that have replicas of some of these features, I think it would be interesting in the conversation, of which the U.S. would be a part, to discuss how this happened and how standards have developed under these other types of laws to address these kinds of issues. With the interesting question being, do you want these kinds of controls to be part of your competition law mechanism, which typically has more powerful remedies associated with it, or is it best handled in another component of the legal framework that arguably has a slightly more nuanced and less potent set of controls to oversee those relations? But in the U.S., in short, the impulses are universal. I think as Jean-Francois just said, they're universal. What's interesting is how they moved out of the antitrust neighborhood and moved into another area where they're dealt with less powerful tools.
Although I don't want to go too far down this road, I think the FTC has a track record of sometimes criticizing some of those state laws and rules as being anti-competitive, if that's...
Only the bad ones.
Only the bad ones, okay. Yes, well, you said a nuanced approach, right? Yes. Okay. Well, let me turn to Jean-Francois. My own impression, based on the sort of casual empirical work that Josh was referencing earlier, is that in Europe, the member state competition agencies have become relatively more active, both in general and even relative to DG Comp to some extent, particularly on some abusive dominance and exploitative type issues. Do you agree with that assessment? And if so, why do you think this is happening?
Yes, I agree, and well, I would say it's only normal because the commission has a staff of 700, 800 people, but when you add all the staff of all the 28 national competition agencies, several thousand, so they have more staff, so they can tackle more cases, and the commission, in fact, has abandoned entire fields to them. For example, vertical restraints. Since 2004, when Regulation 1/2003, the so-called modernization regulation, came into force, the Commission has not opened a single case on vertical restraints. Now, the Commission is saying that maybe it's going to change its policy and again look at vertical restrictions, but basically, it has left this to the member states. Now, for abuses of dominance, it is true that the member states have adopted more decisions and also have gone further than the Commission, especially in the field of exploitative abuses. But this is because, again, Regulation 1/2003 allows member states for unilateral conduct cases to go beyond what EU law provides, and this was a strong demand by countries like Germany and France, and partly related to their desire to deal with situation of dependency, which would not be really strictly abuse of dominance cases. So it's a normal trend, and I think this will continue. And the Commission, of course, has succeeded in. By creating the ECN, the European Competition Network, has succeeded in creating a system where, even though there is no hierarchy between the Commission and the Member States, still it has succeeded in many cases to push the Member States into adopting similar policies, though of course there are cases where you see aberrant decisions at the national level, but I think that by and large the system has worked relatively well.
So you sort of anticipate my follow-up question, which is some of the markets you allude to where the member states have weighed in are, for example, internet-based markets where
Yes.
the concept of a country-specific market is somewhat less plausible than in other areas, we'll say. So you don't see DG Comp becoming more actively involved other than through the ECN in this area?
Well, for example, in the field of internet, I think that the Commission is allowing experimentation and is allowing member states to take divergent views. Like, for example, on the Booking.com case where Germany and France are not aligned. And so maybe at one point the Commission will step in, but for the time being it seems to be happy with this apparently disorderly situation. You have the same thing in verticals. So the way the rules on vertical restraints are applied in Germany, for example, is not the same as in Holland. Germany is much stricter. So in fact, you have different variations, in different member states.
Okay. For Chairman Chawla, I read recently, I hope I have this correct, that your legislature in India is moving to replace the Competition Appellate Tribunal with what's called the National Company Law Appellate Tribunal. If I follow this correctly, replacing a specialist competition court with a more general commercial court. Can you let us know what the status of this is and what effect, if any, you think such a change might have?
Yeah, that's right. This is going through the parliamentary process, and the stated objective seems to be that the government feels that over the years too many appellate bodies have been created. As it stands, has not done too much in terms of output. So jurisprudence has not really effectively been built, even though the time period has been only 7-8 years. But that said, I think the point is not to pass any judgment on the appellate tribunal's work, but I think the point is that it doesn't seem to be a good move, because replacing a specialized appellate tribunal where the members and the judges over a period of time, even though they may not have very long tenures in those positions, but they develop a kind of basic competence and expertise in handling competition matters. Now, to let all that go to a more broad-based appellate tribunal which will handle all kinds of matters under the company law, and competition will be one part of the architecture, is, in my view, a retrograde step. I don't think it would serve the cause of competition well, but that's the state of affairs.
I'll ask whether any of our other panelists have a view on whether it's better for competition cases to go to specialist courts, or, I mean, in the United States, they generally go to a federal district court and can be tried before a jury in private cases, so even less specialized than federal district judges. Do you all have a view as to which is the better approach? Andy?
Yes, I mentioned in my presentation, the competition case will be reviewed by administrative court in Taiwan. So that's a type of the specialized court. And I think the result is mixed. According to my personal experience as a commissioner, some of the judges in the administrative court did do a very good job. They are well trained and they are very experienced in handling all these competition cases. But some of the cases is poorly decided. And as time goes by, I could sense this feeling that they are special court, because by special usually mean professional, but as time goes by, they were treated they are special. Mm-hmm. They will emphasize on the speciality. They are special court, so they have this turf feeling that it belongs to me. So the decision should not be challenged, something like that. So the result is fixed. But personally, I think to try to review the case by the regular ordinary court will be better, my personal opinion. Just put it on the regular proceeding and regular principle, the trial principle. I think they should handle the case well. All you need to do is train the judge to be more familiar with the competition issue, and they can do it within the regular legal judicial system. Yeah.
Okay. Bill?
Yeah, I think Andy picked just the right description. Mixed is the result. It's evident why a number of countries have done it. Yeah, they're starting with a judicial system that is so beset by arteriosclerosis or other failings that they feel a decided need to bypass it by creating something else. So it's an effort to take a judicial system that in many ways is not functioning well and to establish something else. That describes experience in many jurisdictions. In some of these countries, you've had a good result. I would say in South Africa, for the most part, the relationship between the Competition Commission of South Africa and the tribunal has been constructive, critical, and useful. I think Andy also put his finger on exactly the tension that arises, which is the members of the special panel, I think, in many instances have had a difficult time deciding whether they want to be judges or policymakers. In a number of instances, they want to do both. They want to run the agency and they want to decide the cases as judges. So they take what I would suggest is an unusually aggressive role in trying to steer the agency to make choices that one might argue are in the province of the policymaker appointed to run the agency. As Andy put it, I think the tribunal, the specialist tribunal, a danger is that it starts to think, I'm going to do both of those jobs.
Yes, I agree. I mean, it doesn't matter which system you use. You need to appoint good people to the court, and it doesn't matter whether it's specialized or not. The general court is not specialized. It also deals with all kinds of cases, and the Court of Justice is even less specialized. Still, there were times when it produced very good judgments.
I was going to say, clearly the best approach is to take a former head of the Antitrust Division and put him on the D.C. Circuit, and that works out very well, right? Right, Judge? You get both. So let me turn to a question for Bill. You are, I assume you're aware of a report that was recently issued by a group sponsored by the U.S. Chamber having to do with competition issues, competition policies, and one of the things that they suggested is that trade officials and trade law should play a greater role in competition issues on the international front, including, for example, the idea of imposing trade sanctions for companies or countries that use their competition laws in a way that are at least perceived to be protectionist. I'm curious as to what's your reaction to some of these suggestions.
If you want to throw the rocks, you better take the glass out of your own house as a starting point. And you better be really careful about declaring on a regular basis, WTO rulings, we're not going to follow them. They don't apply to us. You better be very careful about making statements in the face of individual transactions that signal this one's going to go ahead because of these characteristics, or I want it blocked because of those characteristics. If you want to take the high moral ground and to use the trade-related process to attack what you think to be asymmetries in the application of the law or outright exclusion in other jurisdictions, and you don't want to be called a hypocrite, credibly, you better be careful.
Fair enough. Jean-Francois?
Yes, well, there has always been an interaction between competition and trade. There was a time when the competition people were worried about the protectionist and anti-competitive impact of what the trade people were doing, like, for example, anti-dumping measures. And in the EU, there were extensive discussions about this, and eventually there was a consensus that, for example, an anti-dumping measure should not protect an industry which was found guilty of cartelization. So it was the other way around. So now here, the trade people worrying about the protectionist impact of competition decisions. Now this could happen. For example, 20 years ago, Boeing, McDonnell Douglas. What did the Commission do? It finally forced Boeing to license any new technology which it had acquired by merging with McDonnell Douglas. And at one point, the Commission even considered prohibiting the merger and apparently abandoned that idea when it heard that Airbus was not interested in McDonnell Douglas. But, of course, there was great concern about this in the US, and I remember that a number of congressmen had prepared a list of retaliatory measures in case the Commission would block the merger. And that included, I don't know, eliminating the landing rights of Air France and things like that. So this was retaliation of the type which is being considered in this report. And it's true that sometimes you may have the impression that competition law is used for mercantilist purposes and can overreach.
Okay.
And then how do you react? Because there is no international forum to settle that kind of dispute. So, retaliation may
Right.
be one way.
Okay, Bill?
I think one of the greatest dilemmas for the head of an institution that historically has sought to establish that its decisions are taken on a technical basis using sound analysis is the way in which the debate in the larger political environment frames what happens. I think of the example Jean-Francois mentioned. 2 weeks before the FTC cleared that transaction, Al Gore went to Everett, Washington, and stood in the final assembly plant for the Boeing 747, a big building, 8 of them under one roof, at a pep rally-like environment with the employees of Boeing there, and said, this is an American merger involving American companies, and if the Europeans interfere, there's going to be a trade war. About 2 weeks later, the FTC clears it without a scratch. You'd be hard-pressed to find too many Europeans who don't think that was fixed. I don't think it was at all. I think that's the conclusion the FTC was going to reach, without a doubt, based on the fact that the airlines simply didn't care anymore. Boeing had lost the capacity to compete for the sale of new aircraft. But if you see that sequence of activity, what do you infer? And oh, by the way, our colleagues in Beijing who follow these things, in the list of usable examples and narratives, when you talk about political influence, that's one of the favorites. In case of emergency, explain this sequence of events and how things took place. And you're on the back foot saying, oh no, it didn't happen that way. The vice president said that, and Bob Potofsky probably read it in the Wall Street Journal, the Washington Post, and the New York Times the next day, because those are the 3 newspapers that are delivered to the chair's office. No doubt he read it, but didn't affect him. Try and sell that to a foreign audience.
Yeah, though I think that the FTC was right. I mean, the failing company defense fully applied to McDonnell Douglas.
Yep.
Yep.
Do we have any time for questions from the audience? Sure. Do we have any? Cal, let's start, and then.
Thank you, Tom. I can't resist, as one who has come here from the Great White North, Toronto, Canada, Josh Wright's favorite place. I want to bring a little bit of Canadian optimism to the table in terms of international antitrust going forward. I want to ask your panel about whether you agree that we actually have, despite the growing pains, a number of gateways today that we didn't have 10, 15 years ago. I look at Mr. Kovacic and Chala attending the ICN, 100 jurisdictions participating in 4, including focused on process fairness and focusing, we hope, on issues of inclusion, if we as NGAs are able to bring it to the table, inclusion of industrial policy, the fact that that shouldn't be on the table in front of antitrust authorities, and the very issue at the OECD that Fred Jani put on the table, public interest considerations this past December and June in a way that was never done before. Public interest, independence of antitrust authorities, real serious issues, and BIAC is inputting on that. NGAs are inputting into this at the ICN. We have a new ABA task force that's going to look at public interest, national interest, protectionism. Justice Ginsburg is on it, I'm on it, and a number of others. So the door is open to a serious consideration of problematic issues if the business community wants to step up to the plate and participate and do it effectively with time and preparation. I happen to be more optimistic than some of the comments that we've heard today, and I want to throw it open to your panel.
So even if the glass is half empty, is it also half full?
All those things are valuable, Cal, no doubt, but they're fragile too. And if you want them to advance, and if you're asking, again, the question posed in my case, what is the U.S. role in doing this? What is the U.S. contribution? I'm not sure what it's going to be. I see a path where it could be constructive and helpful in all of these discussions, but I'd suggest to you that this is a fragile process, that in a world where the collaboration of elites to set out these kinds of paths has been subject to a lot of criticism. How transparent are they? How legitimate are they? I don't think the criticisms are well-founded, but I think we'd be foolish to say they aren't fairly loud at times. I would say all involved are going to have to work harder than before to make them successful. And again, focused on the narrow question of the role of the United States in this process, none of that's going to happen by accident. So 3 cheers for the efforts. And they have to take place on this multi-level scale that you're discussing. Public agency interaction, non-government institutions, academics on all levels. That's in so many areas of international relations, that's been identified as the 3-level form of engagement that's important. So bravo to all of those efforts, but fragile and question mark, what is the U.S. role going to be when the door closes and those groups get to work?
Chairman Chawla.
Thank you. I think overall I would tend to agree that the glass is relatively more full than empty, because a lot has happened. I mean, not that we've covered the entire gamut, but lots of work has been done and is continuing to be done at various levels, as was being mentioned, with the involvement of all. And I think it's important also to understand and appreciate that there will be difficulties and roadblocks in terms of, the whole tendency to bring back protectionism to the table, to bring back other instruments into the competition architecture to achieve different objectives, which basically the community should try to resist. The friends of competition as a whole should try to resist. Because if all kinds of people ride on this animal called competition, there's going to be disaster.
Okay.
I have a question for Bill. In terms of, we've heard a lot today about silos and the need for there to be more dialogue, in particular with DOJ and FTC on competition policy. I've seen on the international front where there's been one statement by one policy or one policy group that's been taken as U.S. policy, as the entire U.S. government, whereas that particular issue hasn't been vetted throughout the agencies that might have an interest in that. And so what do you suggest that we do for an interagency process that will be able to solidify one U.S. position so that we can be strong on the international stage?
I accept the inevitability that in a number of areas there won't be one U.S. position, that you'll have a contest of ideas and a debate. I think that's happened from the beginning of the Republic, so I don't see that coming to an end. And in many ways, it's probably healthy to have some discussion and debate that results in dissonance in the process. I would say that I would like the positions that get taken to be the result of a conversation across them. And I say that recognizing that those synapses are hard to create. And even when you declare that there will be a joint collaboration process, those identified as the joint collaborators do not immediately and willingly participate in the process. But my aim, my hope would be that when these documents are produced, it's the consequence of a discussion that allows those with specific expertise to say, interesting airplane you've designed, do you notice that you only have one wing? And our experience is it works better with 2 wings. So that you have designers with a broad base of experience that can bring their views to bear on what position would be taken. So I accept the inevitability of some discontinuity, just because it is such a massively complex body of public institutions. Hard enough to get 2 of them in the same spot. To go to 3, to go to 50, to go to 15, very hard. But this is where the effort to have a discussion process that makes the ultimate decision makers more attuned to what implications flow from a given choice would be very healthy. There are areas where we've done that too. You can point to policy areas where policy is better because that's taken place. But it's not automatic, and these relationships tend to take a lot of time, high-level commitment by decision makers who might not have the job for more than 2 or 3 years. They're basically being asked to build a policymaking infrastructure that has long-term capital consequences in a relatively short time. And if you're an appointee to the agency and you're going to be there 2 or 3 years, how are you going to invest in this infrastructure, which will be almost invisible, for which there are no credit claiming opportunities, no parades on the Great Avenue here for you, no plinths on which your statue gets built. On the facing of most of the statuary here, it doesn't say, she built a great infrastructure of policymaking at the national level, or did a really good job of developing these approaches to achieve a policy synthesis. It says, she brought this case, she brought this regulation, she did this. So to do this requires an adjustment in the perceived incentives by which people measure how good a job they're doing.
Do we have time for one more? One more.
Well, thank you very much for this panel. I just wanted to draw your attention to, early this year, the global accounting giant PricewaterhouseCoopers published a report that by 2050...
Did they deliver it in an envelope?
No, they didn't.
Was it the right envelope?
Predictions about the economy that China and India will be two largest economies, overtaking US 20%, 15%, and 12%. Now, the question that I have for both Professor Andy Chen as well as Ashok Chawla is that with Brexit and with some degree of uncertainty in the United States, what kind of leadership role that Asian countries and Asian institutions, particularly China and India, but also other economies in Asia, ought to be performing, but also are there regional conversations taking place within the commissions in these countries to advance a more Asian perspective into the global discourse?
I haven't, of course, seen the report, but be that as it may, the competition architecture is a very small part of the total architecture, which is going to sort of, even if economies are going to move ahead in the global race and so on and so forth. So the competition authorities may discuss and broadly exchange information to get an idea of what is happening to similar matters there and so on and so forth. But the engagement with the competition authorities at that level is not going to lead to big changes in the larger policy architecture, which are going to drive those kind of outcomes that perhaps PricewaterhouseCoopers has on whatever basis determined. So this is not really going to be integral or not going to be very substantive in terms of the entire thing. But if you ask a general kind of thing, I would say it's very important that these countries, the Asian countries, including India, and I can only speak for India, we need to be very sure that we continue to build and create very robust institutions and follow extremely good rule of law. I think these two things are going to be very important wherever we are going to get in 2050 or not.
You mentioned about large economy. I don't think Taiwan is a large economy. We could lead the world, but that's our dream. Yeah, I think everybody has mentioned about China, especially competition law. But please don't forget, we have the competition law in Taiwan for more than 20 years. We are very experienced enforcement agency, even though we are a small agency. So actually, I think we already have those foundation for enforcing the competition law. And I think what is required, what is needed in the future is some change in idea regarding what competition law is all about. Within the agency, I think we should build up a culture that competition law is to protect competition instead of competitor. Even though we mention that quite often, but in implementing it, we still have some problem with that. And the second improvement that could be made in the future is that we probably need some resources, especially I think the the chairman India mentioned about the human resources. I think that we still need more resources into to this agency to deal with all these very complicated issues, such as the what is happening right now in the high-tech industry. This requires a lot of challenge, require a lot of the energy and resources that need to be put into the investigation. So if you ask my opinion, I think there's the two improvements that could be made in the future. Thank you.
Okay, I want to thank our panelists for the well thought out and insightful remarks and for the opportunity to the organizers.